write a note to myself that I don't need, I can't get up fast.
You are so accommodating.
I try to be. Thank you. All right.
I feel bad. I keep asking you to do stuff for me.
The only thing I have a request is I do need like 24 hours, you know, only
Yeah, I
because
really wanted to get things.
I
done,
know you did.
But
I know you're so busy, but give me a heads up if it's not going to too, because like this morning I had a couple meetings, so I almost didn't catch your email, and I would feel awful if I attended the meeting and I was like, what email? What? I'm supposed to print stuff out, do you know? So, I just try to, I know it's hard. I know you're so busy. So whatever you can do, because like I said, I would just feel so bad if, you know,
this week has just been crazy.
yeah. Great. Hi, Rebecca.
Which has a very kindly printed and collated and everything, so all I have to do is grab a bunch now and there.
Perfect. Hi, Rebecca. Oh, hang on. Oh, you're on mute.
Yep, sorry. Hi, how are you?
See, can I hear you now?
Can you hear me?
The memo
Oh,
about.
I gotta play with the owl. Hold on one second.
Packet of handouts for you.
The handouts that we sent this morning.
Yes, I emailed them to you this
Yeah,
morning.
I printed them out. Okay. So I've been upstairs at the. fourth
Rebecca, see if I can hear you now.
floor.
I can hear you. Can you hear me?
Yes, thank you. That owl for some reason is always on low.
So I have that we are meeting on the fourth floor in room 400.
For today?
Yeah, that's what the agenda says.
Oh, I had sent out a correction email saying they had to switch us.
I didn't get that.
Oh, okay, I'm sorry.
Yeah.
I'll go through and look.
I'm glad you found us.
Well, it's 1 or 2 rooms is what I'm thinking, but yeah, no. Was it somewhere in that package this morning?
No, I had sent it out like the
No.
same day, right? You had gotten it.
Yeah.
And you had gotten it, and
Yeah.
I'm positive I had you on it,
Yeah.
so,
No, I didn't.
Okay.
I didn't see it, so.
yeah, they switched us. It was like 2 days, I can't remember, same day or the next day, scheduling called me and said that room's taken. So you can't have the meeting.
Oh, really?
So then they. moved us upstairs.
It's very empty.
Well, it didn't start till 2:30. So she said we can only accommodate, and I knew sometimes depending on how long we go, I didn't want anyone to be cut off too early
Okay.
because of the work, so.
September 22nd. Okay, let's see this.
So Rebecca Graham is here, Carla Black is here, Roberta Mancher's here, and Catherine Nadeau, right?
No.
Nadeau is here.
That's not.
Okay, so I think. Rebecca, did you want to say anything before we begin, or is it okay if we just jump into what the stuff that Roberta has prepared for today?
We can, I can go over this, I guess, in the larger meeting too. There were a lot of kind of misconceptions that were in or reflected in the meeting minutes. And I feel like we need to do some correction around that, because this is public information and we're supposed to be a public body. So we need to make sure that what we're putting out is accurate. So I think that some of that might come out as part of the discussions that were in there. So whatever is the best use of this time, we can dig into. I'll have some more detailed comments around the material for the next meeting as well.
Okay, yeah, it's up to you. I can give you 5 minutes now or 10 minutes or whatever you feel you need, or we can start and take it from there, and I have you so we can see you and stuff. So up to you.
I'm fine with letting her go first.
Yeah, so it's up to you.
Okay, well, so I need to, I think, clarify a couple of things about what MMA's role is in this. We provide a number of services to municipal government. We are a member. And I think there are some misconceptions maybe amongst this group about what our role is in that. And our role is to make sure that municipal officials are adhering to the law. Whether or not that law works out well for you, I guess, you know, that's the matter of debate, but municipal officials have to work within the bounds of their law. And they are unable to do certain things, even though there are people that are stuck in these situations. There are very good reasons why they are finding of fact based cases and why they require that legal review. In my mind, all of the issues, if you looked at them individually, all the people that presented to us, every single one of them has nuances of fact that the courts are best to sort through. And some of the issues around that are the ability and access to those courts for those individuals. So the access piece, I think, is about providing agency for those individuals to have their cases heard in an effective and timely manner. And that may mean, you know, the creation of some sort of ombudsman's program or negotiating program. And we've talked about that before. The access piece, trying to approach it from a statutory realm, is really fraught because all of those cases are very specific insight. So they need to have established facts as to who ownership is, what type of easement existed, what type of negotiations were around that. And rolling over one has knock-on consequences for the other. So those are really important pieces that we need to make sure we're not continuing, as we have historically, to make it even harder for people to get that agency. Because every time we mess with this law, it makes it harder and harder and harder for individuals to actually move forward and have and understand what their rights are. We have another whole group of people that have moved in and made a conscious decision to not use the programs that are in place, such as title searches, such as surveys, all of the things that are embedded in real estate programs. They've chosen not to take them. So that is a risk that they have assumed that should not be placed on that community. They made a decision to make that investment. It's not the community's problem that they failed to do their homework, which is why the Roman concept of caveat emptor continues to be what mitigates out. If you do something and don't do your homework, then it's up to you to figure out how to get yourself out of that. It's not for the community to do that. So while, you know, title insurance may or may not be part of every single transaction, there are an increasing number of folks that have moved into town and did not do their due diligence and would then like the community to share the burden of that. And that includes seasonal camps that were purchased with the understanding that, or the belief that they were going to be able to live there year round. That community has the right, and we need to make sure we're protecting that democratic process to determine how much of their local resources actually are expended upon trying to help someone that mitigates that. It sets up an adversarial process, but forcing folks to pay for that when it has been historically seasonal and you have a new use is kind of an important thing to protect. They need to be able to understand whether or not they have the capacity to grow that. They've made decisions historically about those roads. It's the same with seasonal and winter closings. Ryan and the county is facing a number of folks that have moved in that don't understand that the county does not plow all of its roads for very good reason. They have very few resources, and they have posted what those roads are and which roads exist there in all of the town offices. And they've had people move their sight unseen, not even understanding the level of snow that hits Aroostook County. And he doesn't find out about whether or not a application comes in for a building permit, because there is no restriction. You can build wherever you want. You can do whatever it is that you want in the unorganized territories. But when that person can't get to that home and they haven't done their homework, then it becomes the wider issue and the wider problem. And we really need to make sure that we protect this nuance where there is some responsibility on the person that's doing that investment. They have a right to have the property, they own the property, and they have rights that are associated with that. But they also have a right to fail in not achieving what they thought their goals were because they didn't do their homework. And that's kind of what the court system has established, and why we need to make sure that this finding of fact is in place. There was some commentary around common law and changing that historically. And I think maybe it would benefit, and maybe Chair Katsifikis is the one that needs to do this, but going into what common law is and how it is developed, I think is important. You can't change common law with statute. Common law is judge-made law, and it has to get adhered to and reviewed, regardless of whether or not there are folks that don't like that it exists. You can't change that without a judicial process. Again, why that court process is and that finding of fact is so important to every single one of these cases. And it's the same with determining what the status of a road is that a community hasn't maintained previously. Making a legal declaration by that community has a formal process that it has to go through. Whether that is to take that road or to declare it as their road, as a public easement, there's a finding of fact that could go against that. So that says, no, there actually is no easement. And there's been history of that as well. So those are a few things that I wanted to call out about the meeting minutes that are there. But our legal processes advise municipal officials to adhere to the law. And whether or not the decision is something that folks like is a matter, that we can talk about. But the core basis is that's our role. And we're not going to advise our members to do something that is illegal. We're not going to advise our members to violate someone else's rights, because the courts are the ones that need to sort that out. And we understand how frustrating that is, because municipal officials are sued every single day. And that process is laborious, and is it expensive? And it's not a great use of time or public funds. So I think when you're talking about in terms of access, we need to think about access to the justice mechanisms that exist for individuals. And some folks have capacity to engage that, and they will engage that, but other folks don't. So to the extent that we can focus on that as an issue, which we have historically flagged previously, I think is really important to that access piece. But I'm happy to answer any questions that you guys may have around it. Any questions around site-specific issues? I know that every single issue that has presented has a lot of alternating sides to it that we didn't hear. And there are some really clear reasons. I can at least lay out reasons why municipalities can't weigh in on certain road-related complaints as they stand currently, that are ones that we've heard before us, if that would be of assistance.
Can I ask you a question?
Sure.
Rebecca, were you planning to spend the rest of the day with us? Because we
Yes.
have some, oh, good, thank you. All right. Because there's some pretty tricky things, and I was wondering your intake on it, so.
Anybody else have any questions?
What was her answer on that? Is it yes or
Yeah,
no?
she's sitting here. Yeah.
Okay.
I think there's no questions at this time.
Okay, first of all, Rebecca, I agree with you on several things, which is nice. The part about access to justice is huge, because in so many cases, the people don't have access to justice. A lot of people who buy property on these roads, the reason they buy the property there is because it's cheap and that's what they can afford. And then once they're there, they're finding that they're pouring some of their hard-earned minimal funds into maintaining the road while the public comes in and tears it up. And so that leaves them with even less to spend on a lawsuit. And it may come down to a question of, well, which is more economically feasible here, to put money into an attorney or to put money into the road. And if they put money into the road, they're going to have to keep putting money into the road, but at least it's a little bit at a time and not all at once. So they often end up going with that option. But what often happens is when people can't get access to justice and they can't get any enforcement because nobody's quite sure what to enforce, because as you said, it has to go to court to determine that. That's where people get frustrated with each other and start either putting up locked gates or putting boulders in the road or taking various weapons up against each other, which we've seen altogether too many times. And there's got to be some way to provide a place where those people can go and get a decision in a timely fashion that will sort out what some of these issues are. So they end up just not just being frustrated over it. So that's one place where we agree. I also agree that when somebody moves in onto a road that has not been maintained in the winters, that the town shouldn't be just required to start maintaining it. But there are also cases where somebody already lives on a road and the town decides to close it to winter maintenance. I don't think they should be able to close the road to winter maintenance if they've already been maintaining it in the winter. If they haven't been, then they should at least excuse me, they should at least allow that person to plow the road themselves. And I think there needs to be some way of posting the road to say, this road is not maintained for public use. Caution, use at your own risk, something to that effect. I know
There already is that provision. And there's a process if someone lives on that road as well. They don't usually do it, but the cases that we're hearing about are people that have moved in and would like to live there year round, as opposed to seasonal. The seasonal, the closures happen in the 10-year period, and it goes before a public hearing to talk about that and to revisit that. The liability piece for plowing the roads and that individual plowing the roads, I agree the sign is probably a good option, but again, striking at that limited liability, we need to have that in place, because there isn't that limited liability when it is a public easement for an individual to go in and plow that road. So as it stands right now, without that change on that liability piece, municipalities are better off not doing anything at all or allowing that, because they're on the hook for everything that happens. That community, if someone goes off that road, is on the hook for that. If someone doesn't plow it right, if that individual damages their truck in that process. And usually these aren't great roads anyway. So there's a liability piece that needs to be dealt with there, that it doesn't exist for the individual that's doing it or for that public easement.
Yeah, that's another place where we agree is we need limited liability, both for people plowing roads that are close to winter maintenance and for people who are maintaining discontinued roads that remain public easements. So that's another place where we agree. I also agree that access depends on the specific facts. Sometimes finding those facts is difficult, and that's another piece we're working on. Pete Coughlin has made a good stab at making some of the information more available. But part of the problem, I think the real estate disclosure laws that went through a few years ago, that was an excellent idea that unfortunately isn't working out as well as we had hoped, because there's nothing saying where they have to get the information. And often the information that goes out on these roads is not accurate. It may be because the seller was told something by someone and what he was told wasn't correct. I don't know whether there are cases where the seller may say what he thinks he needs to say to get the piece of property to sell. That's another risk.
Billions of them. That's why, you know, you have title insurance so that you can come back on that. There are cases where municipal officials have reached out to the real estate agents to tell them to stop advertising property in specific ways that they knew is like completely untrue. So, but that doesn't, they have no agency to stop them from doing that either. And that is why there has to be some onus on the part of the person that is making that purchase. And that is why it's such, like, the traditional ways of buying property have those checks and balances to try to protect that buyer. How we deal with people that don't use them is a whole other realm.
And I think another thing that enters into that is that sometimes people read what it says in the disclosure, but they don't understand what it means. So they'll see private way or they'll see public easement. They'll think private way means a private road. They'll think public easement means, oh, the public must take care of it. So I think along with the disclosure, there has to be some explanation of what that means. Another law that was well-intentioned but has not worked out well is the one that says that when there is no road association, it's assumed that the property owners share equally. And I have some suggestions for how that could be amended to make it a little bit more accurate. Because what happens now is people are saying, yes, it's a private road, it's shared, maintenance shared by the abutters. And I know of at least one case where there were two buyers buying different pieces of property on the same road. One of them was told that it's a private road of maintenance shared by the abutters. The other one was told that it's their private property. And so then you get a conflict. Both of them thought they had accurate information, and yet the information is conflicting even on the same road.
And that's key to why the homework needs to be there. Sorry, that's key why the homework needs to be there on the part of that person that's purchasing that property, and why the title searches and the attorneys that are involved in that. I agree that there needs to be more education that's shared in there, but again, that's a finding of fact. And there, you know, it's really hard to legislate being a decent human or being a good neighbor. And
I can tell you 3 or 4 cases where there was title insurance, and you would think that the title insurers would do the due diligence, and yet they haven't. In one case, the title insurance company said, oh, well, if that's the case, we're just going to give you your money back for the title insurance policy.
Depends on what you purchase on that.
Excuse me?
It depends on what you purchase on that. There's a couple of pieces of land that are off of a private road that didn't buy into it. They weren't part of that development, but it's the only access that's serviced by that road. And there is no on-ramp for that parcel to be a participating member of that road either. They can build their own road access to it, but if they want to use that road, they're not part of that road association. So I mean, it really cuts both ways. There's no on-ramp for them, but the title insurance companies are saying, nope, we're not going to insure this because we know that this issue exists for that piece of property.
Well, it's one thing for the title insurance company to say, we're not going to insure it. I think it's another thing for them to insure the property, give the person the impression that the due diligence has been done by the title insurance company. And then when the person has already purchased the property with that assurance, then they find out that the information they were given was not accurate. And then the insurance company backs out on it. So that's right.
And I mean, again, those are like, that's like facts, specific, and there is probably a system of failures that have happened there as well. And that's why there needs to be that judicial review.
Okay, now another point is that having each person do their own due diligence, it's taken me, what, 42 years to learn everything that I've learned about where to find the information, how to interpret the information, what the information means. And you can't expect somebody who is looking at closing on a property in a few weeks to be able to learn all of that in order to make an accurate determination of the road. Even myself, when I'm doing research on a road, lots of times what I think the status of the road is changes several times as I find out new information from different sources. So I may first say, oh yes, the road is discontinued with a public easement retained. And then I find out, oh, that was what the warrant article said, but the article didn't pass. But then I find there was another warrant article at a different date, or I'll find out that the county had already acted on it before 1976 while it was still a county road. Or I'll find out that, oh, this goes in a perfectly straight line parallel to the town lines. This was a rangeway and you can't extinguish it. So how do you expect each person to be able to do that due diligence? Wouldn't it be better to have people who are trained in it, who could do the review on these roads, whether it's on a case-by-case basis or whether it's trying to get together a database on it? I still say that it doesn't have to be done all at once. If we can take the easy ones first and have towns just record what the easy ones are, then the difficult ones can be attacked one at a time.
Yeah, that's, I mean, what you're talking about sounds great in principle, but it's, again, not easy. That can be a takings. It could be completely inaccurate. And there are other ways in which roads are developed over time that don't involve the town, but involve the public use of that road. And those are all nuances that deserve and have their place, which are really important, I might add, to the entire foundation of the state of Maine. If we didn't have those prescriptive uses and that investment in a piece of property to improve it, the state of Maine would not exist as it does currently, because that is the history of how it developed and why we became a separate state from Massachusetts. And it was about that agency. It's about the agency that you're talking about. And that is where I think all of those pieces fit. If you're creating an alternative dispute resolution process specifically for this purpose, then you're also going to establish a number of cases that establish the status of that road. But it's being brought on by the people that have the skin in the game. Because if you make an investment, you have a right to have it grow. You have a right to have it not grow or fail. And we have to talk about what part of that is the public's problem and what part of that is the person who's making that decision's problem. And I get that we can be emotional about houses, and we definitely are, but they are two separate issues within law. And we need to make sure that the agency is there for the people that live in that community to weigh in, because there are mechanisms. And if we had that resolution piece, then we would have somebody that would be able to be that advocate for them, that goes in and says, okay, well, you can make a case that this is a public easement and that town can allocate funds for the purpose of making it better. And it diffuses the personalities from those conversations. And it creates a process where people are using information and buying into it. And then they're being, because it has to be burdened by everybody. And an individual's choice to buy or invest in property should not necessarily become the larger community's problem if there hasn't been the use of those things that they have at their disposal. And if that use is a challenge, then again, that mechanism is that alternative dispute process. Or, as you know very well, people with capital have lawyers. People with capital will restrict access to places that historically people have used over time simply because they bought a piece of land on that. So it works both ways, and we can cut off entire communities from resources that they have traditionally used by the same processes that individuals are using to cut off other people. And that's why we need to have this bank. So if we have case-by-case decisions, then that is where your database comes in. Those decisions get made. then that status of that road is enshrined. Prescriptive use comes into play on places that have not had an easement on them or were extinguished before counties, before the counties gave them to the municipalities. Even if the town has used that the entire time, the town can't take that back. The town can't make a declaration that that's a public easement because it has no authority to do so. It is private property for all intents and purposes, but that prescriptive use can be used as a mechanism in a court process to establish that there has been this historic public use, and therefore there's an easement by prescription that can happen. And there are a couple of cases that we've heard about where that can be used. Whether or not those individuals can access that is the true question. Can they go, do they have the capital to go and fight that, or do they have the capital to actually, or is there a process that can do that? People with capital will always have access to those court processes. People without will not. And the issues clogging up the courts, like if we had an alternative dispute resolution process, then they wouldn't be clogging up the courts either.
So do you have any suggestion for how to set up an alternate dispute resolution process?
It requires cash from the state. The state has to invest in that alternative dispute resolution. And I know that this committee has, proposed that as a problem, and we need to get the legislature to get behind it. I think that, and I think it's becoming a larger issue within the civil process. Not just on this issue, but there's a real inverse that's going to be probably even more acute because of the influx of folks that we've had moved to the state.
I've heard that from the DOT, I've heard it from the counties, I've heard it from various sources that they're seeing more of this. So why don't we take a look at some of the suggestions that I had. Let's start with an easy one here about the limited landowner liability. I say an easy one because it's only one page and some of the others are several pages. What I did was I looked at some of the existing laws that we have on limited liability. There's Title 14, Section 159A, which is limited liability for recreational harvesting activities. And there's Title 7, Section 4103A, which being a horse professional, equine professional, I'm familiar with it. It's limited liability for equine activities. And both on this one and on the other page one that I had, which is closing of roads in winter. I think I used one of those statutes as a model for one and the other statute as a model for the other. So I came up with different answers here and I don't know which one is better. Or if there's something else that maybe Rebecca, you could suggest that would be even more effective. But on the limited landowner liability, what I suggested was liability. A landowner, resident, lessee, contractor, or any other person engaged in maintenance of a privately maintained road is not liable for any property damage or damages arising from the personal injury or death of a person traveling upon the said road by foot, horseback, human-powered vehicle, motor vehicle, ATV, snowmobile, or any other mode of transportation. Except as provided in subsection 2, a person may not make any claim or recover from any person for any property damage or damages to personal injury or death resulting from the inherent risks of traveling upon a privately maintained road. Each person traveling upon a privately maintained road assumes the risk and legal responsibility for any property damage or damages arising from personal injury or death that results from the inherent risk of traveling on a privately maintained road. It is the duty of each person traveling upon a privately maintained road to act within the limits of the person's own ability to maintain reasonable control of the vehicle at all times while traveling upon the road, and to heed all warnings and to refrain from acting in a manner that may cause or contribute to the injury of any person or damage to property. 2, exceptions. Nothing in subsection 1 prevents or limits the liability of a person who performs maintenance on a privately maintained road if the person A, commits an act or omission that constitutes reckless disregard for the safety of others, and that act or omission caused the injury. Failure to remedy conditions caused by acts of nature shall not be considered an omission. For the purposes of this section, reckless has the same meaning as recklessly defined in Title 17A, Section 35, subsection 3, paragraph A, or B, intentionally injures the person. And I realize one thing I didn't include in here is also stating that the municipality has no liability. That probably should be included in there too.
Well, municipalities are covered by tort law, so that would not that wouldn't be unnecessary.
I think it's, is it missing environmental damage too?
That's a good point, because currently there is something that makes them liable if there's environmental damage. It makes the landowner liable if somebody else comes through and uses the road and it results in environmental damage. That's a good point. I'm going to note that down. Okay, Kathy, when you're finished making notes, any other thoughts you have on it?
I need to go through that, the way that would get maintained, because I'm not sure that you can ascribe a duty within that, but you also need to cover negligence. So a negligent act as well.
Now, what would be considered a negligent act? For example, last winter, we had an ice storm and our road turned into a sheet of ice. And we don't have the facility to sand 6/10 of a mile of road. We don't have a sanding truck, and we're not going to do 6/10 of a mile by hand out of a bucket. And my husband was the one who slipped and fell on the ice and whacked his head and got a concussion. What if it had been somebody else? Are they going to blame us because we plowed the road? And if we hadn't plowed the road, they wouldn't have tried to drive in.
You just nailed winter closings, and why our recommendation to towns is to not let anyone plow it because of that.
But if you don't let anyone plow it and somebody lives there, then you're basically denying them access to their home for a good part of the year.
Well, you have a different kind of road. The winter closing roads are ones that do have a maintenance standard on them, and they're closed for winter passage.
But still, the question remains, what constitutes a negligent act? If there's some, I did put in there acts of nature. If you have a flood that washes out a culvert, and if you have an ice storm, if you have a sudden snowstorm, if you have torrential rain in the spring and it turns into mud up to your axles, those are not necessarily things that the landowner who's maintaining the road is going to be able to correct.
I think when we had the meeting on Tuesday for terms, didn't Jim give like some type of language for that? And I can't remember what it was. He had listed, I think, out what the level should be. And I'm sorry, I'm drawing a blank on the wording that he used because my brain is a little tired today. But I think he didn't, am I mistaken? Didn't he?
Can go back and watch the video and see if I can
and I'm
find
trying to
it.
remember, he didn't use the term negligent. He didn't use best to the ability, but there was some legal language that he had said. And I'm sorry, Rebecca, I'm drawing a blank, but that was something that was discussed Tuesday on the terms committee, on the subcommittee, and Jim had made a recommendation, and I just thought, let me just say that. And I don't think he said negligent, though. I can't remember what it was that he had said, but he said there was some sort of standard that could be used. And I'm sorry, I'm just drawing a blank. Look at my notes and see.
Yeah, I'm looking at those notes right now.
Oh, but you don't have this past Tuesday's notes, though.
Oh,
That I haven't done the
that
minutes
was
yet.
September 12th.
He might have mentioned on September 12th too. I think this has been a long ongoing discussion, and I might be wrong.
There's a statute that we for limiting liability for all intents and purposes dumpster diving on dumpster divers. and like pulling stuff out of stacks that are like non-OSHA standard. But there is a statute that just got reworked for that, and the language would be in there, and I'll see if I can dig that up.
Yeah, 'cause he had mentioned something, and it was a really good standard, and I apologize that I don't have that up in front of me. Let's see if I can
Rebecca,
find
do you
it.
know what the statute number is for that by any chance?
The
Or what-
dumpster diving one, yeah, I gotta go back and find the law.
Okay, if you can find it, please let me know, I'd appreciate it. And then the other one, the closing of roads in winter. I added in, the road shall not qualify for winter closing if there is or are currently one or more year-round residents on the road at the time the winter closing is initiated. And then I don't know why I have a 6 there, because it looks like there's only a 1 before it. If any person shall take up year-round residency on a road that has been closed to winter maintenance, they may petition the municipal officers for alteration of the order pursuant to subsection 4 of this section. Yeah, that's what I did. I left out the ones I wasn't changing.
They can
Um,
already do that.
Yeah, I just thought it might be clear to have it right in the law so that people would know what the possibilities are. The municipal officer shall be under no obligation to alter the order. 7, if a person shall take up your residency on a road that has been closed to winter maintenance, they shall not be prohibited from providing their own winter maintenance. The person who provides such winter maintenance does not have a duty of care to keep the premises safe for entry or use by others, and is not liable for any property damage or damages arising from the personal injury or death of a person who uses the road. They shall notify the public by a sign or signs which must contain at least the following information. Warning, road not maintained for winter use by the public, pass at your own risk. The message on the sign must be of durable, the sign must be of durable material. The message must be in black letters at least 2 inches in height, and the sign or signs must be placed in a clearly visible location at the entry or entries to the section of road for which they are providing winter maintenance. Limitations on subsection. This subsection does not limit the liability that would otherwise exist for willful or malicious failure to guard or to warn against a dangerous condition. I don't know if that language is any better or worse than the other one, or it would kind of be nice to make them uniform.
Yeah, because this is the first day that I'm looking at this, Roberta, I need to dig down into it and provide the appropriate subsection. Sometimes spelling things out in the same section of law or a different section of law has the opposite effect of what you think it does. So I need to spend some time with the actual language.
I wonder if this, I sound like a broken record, I always bring this up, but is this beyond the scope of our duties? I know I'm not suggesting that it isn't a problem or that it shouldn't be addressed, but
yeah, I think to your point, Heather, like the recommendation should be that we figure out how to limit liability for folks.
Right, I agree with the limiting of liability. I'm talking about the winter closings.
Oh, the winter closings. I mean, the winter closing already has a process that is assigned to it. I mean,
I'm just wondering if it's beyond the scope of the work of the committee.
Yeah, I know initially, Jim had said that he thought it was beyond the scope of the committee, but then when I kind of explained why I thought we should look at it, he seemed to be agreeable to the idea. I may be reading between the lines where I shouldn't, we can ask him. But my thought is that when you close a road to winter maintenance, that's essentially a temporary discontinuance because you're not providing any maintenance. And
but there's a clear process around that. There's a very clear prescriptive process around it. And
but the process doesn't necessarily make it right. And that's what we're trying to fix.
well, the process balances the responsibility to pay for that by the community in balance with the use of that by the community. So it is a balanced process. And if there are issues that where someone's being shut off for those types of roads, then and they're closed for winter maintenance, I think Ryan would be the one to be able to speak to that and weigh in, because he's the one that shoulders the largest burden of them. They happen, you know, in many counties, but astronomically, that number of roads that would have to be maintained in a rustic is unachievable, and they have it with good purpose. So
Okay, and I had a couple of thoughts and now I've lost them.
Well, while you're thinking of your thoughts, I have a road in my new town where I'm living that is close to winter maintenance. So I went down there and there's not just one person, there's multiple people on it. The problem I have with that is the ambulance, is the any emergency vehicle, fire trucks, anything that has to get down there cannot get down there unless we let these people maintain it so that they have this peace of mind where the town can not take care of it because of finances, but let the people do it and let them have, because they all have, you know, as far as I know, as far as I saw, they have these vehicles that can plow. And so we need to make it at least passable. We need to do that for safety reasons. That's my biggest peeve. I'm a broken record too, so that being said,
so municipalities do go in even on private roads that haven't been plowed and plow in front of the emergency services. That is something that does happen.
yeah, that's private roads.
But
Yeah.
no, on any roads that aren't maintained, they'll take the plow truck with them in order to get in, to get
Okay,
access.
my question in response to that is, when was the last time you had a plow truck fly past you at top speed with its lights and siren going? And when was the last time you got stuck behind a slow moving ambulance or fire truck?
There are times in which there have been multiple officers that have been stuck trying to respond to things and had similar issues on roads that are publicly maintained. So this is not an unusual situation for them. This is something that is part of normal winter in Maine stuff. And the folks are usually out. The plow trucks are usually there. And they're having to pull out oftentimes the emergency vehicles themselves. So it's not abnormal for that to not be a part of that response.
But if we can prevent that from happening, because time is of the essence when it comes to someone having an event, say heart attack, strokes, yeah, these are all time sensitive. So for them to say, well, look at the police truck out there, or the guy that says, oh, I'll open the gate if I know they're coming. This is all to me a bad scenario. So winter maintenance closure, if the person that lives on the road, the people that live on the road can take care of it and not be deemed you broke the road up, now you have to pay for it. If they could have some kind of limited liability, to me that would be owls talking. Is that you, Rebecca?
I don't know. I mean,
okay.
that would be, you're 100% right. It's the limited liability piece. We can't advise towns to do that because they've opened themselves up to that liability and they've opened that individual up to liability. In all actual reality, nobody's going to enforce it. If you go and plow, I mean, there's no town manager that's going to come knocking on your door, or code enforcement officer. Did you plow this road? It's the problem. The problem is when someone goes off. Someone goes off.
And I'm afraid that in some cases, that is exactly the problem, that they will come knocking on your door saying you wrecked up this road in the wintertime and you're going to have to deal with it. You know, not everybody is, say, well, I live in Mount Vernon, not everybody's a Mount Vernon area people, which I find are the kindest people, but
I lived in Mount Vernon.
Yeah, I love it. I've only been there 6 months, but I am finding winter closure roads, and it's kind of now that I'm on this, I'm like being more cognizant of what is taken care of in the winter and what's not taken care of in the winter, and that scares me to death, not for me, but for people. You know,
Well, these are campers. I mean, generally they have historically been seasonal, and now people want to live in them year round. So there's ample opportunity to open up that conversation within that community. But sometimes the road is not at a great standard because there were camp roads.
but this one isn't. This one is a mountain road. And it's no lake road. It's not a seasonal. This is a mountain road. And they close it for winter maintenance because between here and there, there's only a handful of people that live on it. So that's why they're closing it for winter maintenance. But there are those handful of people that live between here and there. And that's the part that we can't let them go unnoticed, because we are an aging population and we need to take care of our older people. That's my take on all of this, and that's where I'm at. We can't close these roads if people live on it. And as far as I'm concerned, if you got a wire that goes down a road, you cannot close it to winter maintenance. Electric wire.
So you can have wire that goes down a really long driveway. So
Yeah.
is that now the town's job, because there's wire that they now have to
That's
make?
the driveway. People are responsible for their own driveways. We're not talking driveways, we're talking roads. So if there's telephone poles and wires that go down a road, not a driveway, but a road, then I think that should be maintained. And it's on a,
Oh.
okay. It was in my driveway a minute.
Oh, I'm sorry, the lights go on and off to save electricity in this building.
Yeah, they do in my garage and my driveway too.
It always scares me, like,
At home.
Okay, I've been noting down my thoughts as other people are talking so that I won't forget them. First thought is that it's been shown by the Maine Supreme Court that damaging an access, not just destroying an access, but just damaging an access requires compensation. So if you say that somebody doesn't have access for, say, 4 months out of the year, isn't that damaging that person's access? Doesn't that require compensation?
It isn't, Roberta. The process is really clear about how to do that. And the Supreme Court ruled on that particular case that the way that the law was written did not provide for that takings clause, or the public process. And therefore that law was struck out of the books. The existing law that is there and how winter roads are processed and how winter roads are noticed and the process by which they have to go through them is established in law. The courts recognize that as a legal process that gives agency to the individuals who live on that road, gives agency to that community to weigh in, gives an opportunity for someone to change that decision equally, and provides that public notice for as well. The piece about the liability is 100% what we should be trying to tackle, so that an individual isn't on the hook if they go in and plow through that. And then the community or the municipality isn't being negligent by not enforcing the fact that they're not supposed to plow it. They're not being, negligent for allowing it to happen, or negligent for anything that happens because it happened. So that limited liability piece needs to exist for a municipality to be able to be empowered to do the things that you would like them to do. And that limited liability piece should be in place for the individuals who are maintaining that road in those roads where there is an easement that is not maintained by that community.
Okay, you're talking about the decision in Jordan versus Canton, which I keep bringing up. What part of due process did it say was lacking? If you look at it, it doesn't say anything about there not being notice, because there was notice.
No, there was no process for that law. The
piece
law
that
by which they used it.
The piece that was missing, which that case brings up over and over and over again, is just compensation for the taking of the access. That's the piece that was missing. There was actually due process, because how did Jordan get his due process? He asked for the court to look at it. And when you say that the abandonment statute provided due process, what it said was you can go to court and declaratory judgment action, which is exactly what Jordan did. And so if that's due process, then it was already there.
No,
And
the
the piece that
law
was-
that they used, the law that was used to cut his access off is no longer on the books.
Yes,
It was
I know.
taken off the
understand
books.
that.
The
I
court
understand
is
that.
looking at that piece of law and it's saying that the way that structure, the way that process, and we should be taking this offline because this is taken away from our goals. But
Okay, we'll skip that one then.
it was looking
That-
at the law. So
My-
if
my-
the law
my
doesn't
point is
exist,
that's-
the court
My point
works.
is, my point is that I think that's why this is something we do need to look at.
I just wanted,
Real estate disclosures,
one second,
can we
Wait,
include with
wait,
real estate?
wait, one second,
Okay.
Rebecca, I'm sorry, I just wanted to clarify something for my notes. For when you were saying limited liability, you were talking about, were you talking also about limited liability for the people who live on the closed winter roads for plowing their own road, or was it just strictly
No.
limited liability for the public easements?
So when there's a winter closure, when municipalities are noticing a winter closure that they're not going to maintain, or they're going to renew what has been a historic winter closure,
Yep.
there's a process that they have to go through. There's, if an individual wants to plow their road and plow to get access to their usually seasonal camp, municipalities can't tell them that they have permission to do that, because by plowing it, they create an expectation. Someone can come behind them, go off the road, and then because it's a public easement, the municipality is on the hook for allowing the individual to do it if they know about it, and B, any sort of injuries or harm that occurs as a result of that. So that is why municipalities, because of the way the statute is written, are advised not to allow that. Practically speaking, I'm quite certain it happens, and that there isn't folks that are going behind and saying, oh, you can't plow. But what Kathy had brought up is an important process. You don't necessarily want that to happen either. If they didn't have the liability piece there, if they weren't responsible for that, but someone does that, then there wouldn't be anyone that was coming and saying, hey, you shouldn't have plowed that, because that individual would also be released from that. Or they would be assuming the risk. They would be assuming the risk of doing it, and they would be, getting access to their property. But if their material is damaged because the road isn't in the right standard, then it's not the town that's going to pay for that plow truck that they use to do that kind of thing. It's prostate in that.
So are you recommending then that the statute changes to say the town would have limited liability in the cases of winter road closing if someone was plowing their own road?
Well, this isn't for their own road. This is in the case like what Kathy is talking about. So, so it's a place where there's a public easement across it already, and it's a maintained road at the other times of the year.
Yeah. Okay. I was just trying to work that out because I thought that's what you were saying, but I wasn't 100%
So
sure.
it sort of works both ways, limited liability on the town and limited liability on the owner. So to me, it sounds like it would have to be both.
It sounded to me like, Rebecca, you were saying that the Tort Claims Act already protects the town, so that doesn't need to be included. It just have to be protection for the landowner who's plowing it.
We have tort claims, but in terms of the way that the courts might look at that is if you knowingly let Kathy run a plow truck up a road that you've closed and gone through that process for winter maintenance, then you're not protected you wouldn't be protected by that, because that's a negligent act or not a trend, you knowingly let them do that.
So it has to be clear that both of them.
So there would have to be.
So if an individual takes that, I mean, I think that the sign, might be helpful. It's probably going to have to be posted that you're assuming your own risk by traveling down this. This isn't maintained by the town and therefore may not be passable, or may be passable only to a certain point. But that that takes there. Now there, if Kathy plowed that road, she's not going to be responsible if someone goes off that road because she plowed that road, technically, maybe because it's a public easement, but there's an expectation of the person coming behind her that, oh, that's been plowed. Oh, I can come up through there. When it isn't plowed by that community, it might not be passable. You don't want her to assume that liability for trying to get to her own house, nor do you want the community to assume the liability that maybe she was drunk when she plowed it and she went all over the place. It's now an S curve or something.
We can start with the assumptions here.
Okay.
Thank you.
Yeah, you know, so she plowed it enough to get in and she didn't need to get back out. She didn't care. So
And that being said, there's not a person in Mount Vernon or any town that would let me behind a plow truck. So we need to clarify that too, so.
maybe that's part of the problem because it's really hard to get plow truck drivers, especially in Mount Vernon and Reedfield. They're having a hard time with their contracts. So maybe you should think about.
I don't think so, honey.
I told the town of Fayette years ago that they should just hire David to plow their roads because he'd do a better job of it and he could plow our road too.
Wow.
But they wouldn't take us up on it. Anyway, let's see, some other thoughts I had. Real estate disclosures. Maybe something that should be included in the real estate disclosure is the road closed to winter maintenance. That's not required to be in there right now. But it might help if that was in there too, so people would know if they're moving onto a road that isn't going to be plowed in the winter. Let's
You know, it
see.
strikes me as something that might be interesting on that, like just pointing to like a roads 101 YouTube or something. Main roads 101.
Let's see, an example. Town Farm Road in Paris was a problem way back. I can't tell you how many years ago. I'm going to say maybe 1960s, 70s. I may be wrong on that. But they closed the road to winter maintenance and there was somebody who had a farm in there and he wanted to be able to plow into his farm. And the town said no, and it ended up in court and it was back and forth. I don't know how many times. And at one point, the town was ordered not to close it to winter maintenance. So then they voted to reclose it to winter maintenance. And it was a huge mess. The town had told the person that he couldn't plow it himself. And again, if we could get limited liability for somebody to plow it themselves, then that might solve that kind of problem. Title 23, section 3105A. Is the one that says that if there's a public easement, the town may plow it or may use their equipment on it. The problem that we found with that was that there are kind of two extremes. One extreme is the town of Wyndham, where they're trying to get all their private roads to be in road associations and to jump through a bunch of hoops so that they can officially declare them as public easements, so they can continue plowing them as they always have as a courtesy to their taxpayers and residents. On the other end of the scale, you get Fayette, which actually did vote in favor of allowing the selectmen to use the town equipment on public easements. And we had a bad winter. We had a lot of snow. At the time, all we had for moving the snow was an aging Jeep, and it just couldn't get the snow back. And we asked the town, could you come in just once, make one pass in and out with your wing plow and just widen the road enough so that there's emergency access if we need it. And they said, oh no, that only says we can use the fire truck when there's a fire. If there's a fire, they can do anything they need to, even if it's private property. And our thought was that this should be for keeping a fire lane open. That would be like saying, oh, I can park in the fire lane in front of the Civic Center as long as the Civic Center isn't actually on fire. No, that's not the way it works. A fire lane is supposed to be open in case there's a fire. And that was all we asked them to do, was one pass in and out. And because of the way the statute was worded, it was ambiguous enough to let them just say, no, they only need to do it when there's an emergency. So that's something that maybe could be tightened up. Okay, I think those were all the thoughts that I had on it. So anyway, that we know some of the things we need to work on that. Okay. Let's see, the two more difficult ones are discontinuance and abandonment. I think there are fewer changes in the discontinuance law. 3026A, the one at the top of the page, that says the following is a work in progress. I was just working on this one this morning, so this is by no means finished. But one of the pieces that I think is missing in it, which they did put into the abandonment update, but not into the discontinuance, was not just abutting property owners, but affected property owners. I know a number of cases where somebody has land that doesn't actually abut on the road, but they have maybe a private easement, which they need the road in order to get to their private easement. Or maybe they're in the next town over and the road crosses the town line, and because their property doesn't abut the road in the town, they're not required to be given any notice. And the next thing, all of a sudden, they haven't got any access. So that's one thing that would be a fairly simple fix, is change it from abutting landowners or abutting property owners to affected property owners. And then further down, I have a
So can I back up on that? And the reason why it's affected or abutting and not affected? Because the public notice serves as the notice for affected, because there are more affected parties than just the property owners. And it would be really difficult to determine who is affected. So the abutters are the ones that you can find easy, but it's going to be really hard to determine who's affected. Affected is something that you feel yourself, which is why there is the public notice aspect of it. And if you want, like the public notice goes out usually in a couple of different locations, but most locally it ends up going out. The actual mailing has to go to the abutters, because that's who you can physically say has a definitive interest in that. As far as adjacent, owners or property, like the municipality might not even practically know that someone has an easement over someone else's property in order to get to their property that might be off that road. That might not be something that actually somebody even knows at that time. So that's why the public notice serves as the broader commentary, and the abutters that are very easily defined are the reason that is in there.
Well, what I found is, I think the way you determine who are the abutters are, you just look at the tax map and see whose property is touching the road. And it's not that much more difficult. I've had to do it because of being the secretary of a road association. We're required by the road association statutes to notify all properties that use the road as access, or all benefited properties, as they say in the law. And in order to figure out what the benefited properties are, I had to look up not just the properties that touch the road, but I had to look and see if there were other properties that don't touch the road, but don't have any other way of getting into it. And there were only a few.
But you don't know.
Find them.
Yeah, you don't know which way those properties are accessed. They could be accessed from other areas other
Then
than
you
those communities.
You look at the deed. It's not that difficult. It's not
Looking through those deeds, that is an enormous undertaking. That is an enormous undertaking. Your deeds are adjacent to other deeds. That easement piece can go over someone's land that's adjacent to that road, or it can go over someone's land that's in the other community. The easiest way to get everybody, and to actually roll back a little bit, this is a public way. So it is more than just the abutters that are affected by this. The public in general is affected by this.
That's why there's a definition of who is an affected property owner. An affected property owner is one who has no other access if that public road is no longer access to their property.
And you might not always know that at the time. You might not always know that.
I still think it's not that difficult to find it by looking at the tax maps, and then if need be, check the deed to the property. You don't have to do a whole title search going back. All you have to do is look at the deed, and if the deed says that there is a right of way that connects to Frost Farm Road or whatever, then you know that that's where their access is coming from. If their deed says that there's a right of way from Ohio Ridge Road, then you know that Frost Farm Road doesn't have to worry about it.
But as you know intimately, the right of way is not always attached to your deed. It is attached to a subsequent deed. It's not on the same, it's not with that particular property deed. the right of way and an easement can be someplace else.
Well, if somebody buys a piece of property that doesn't say how they're gonna get there, then they didn't do their due diligence.
Bing, bing, bing.
Okay, let's see, I also put in, definitions. I took out the, best practical notice in red down there because I put it in up above. Section A, right at the top, I added in definitions as used in this section unless the context otherwise indicates the following terms have the following meanings. A, affected property owners means owners of real property that abuts the town way to be declared discontinued, and owners of real property for which the only public access route includes the town way. And then best practicable notice, I put up there instead of down below, because then we got both definitions up at the top. Then down at the bottom of the page where it's underlined, I was adding in, if any property will be left with no other public access route, the public easement must be retained, except that at any time, the abutting landowners may negotiate a shared private easement over the road or any interior portion thereof. And I wasn't quite sure how to explain what I meant by that, but so you've got 10 owners, 5 on each side of the road, and the 2 at the very entrance to the road have no interest in setting up a road association or granting anybody private easements because they have access from the main road, but the other 4 along each side will all agree to it. Why not let those 4 on each side have that part be private, and they can post signs at the end of those first 2 people's property saying, you know, beyond this point, it's a private road. And eventually, maybe those first 2 people will figure out that their part of the road is getting chewed up by people who come in, turn around and go out again when they find they can't go any further. And the rest of the road is in pretty decent shape because there's a road association taking care of it and the public isn't using it. So maybe at some point they'll join in. But the point is that it's not necessary to have everybody on the road agree, as long as the ones that are farthest in agree. So that was my thought there. Upon such successful negotiation, the public easement must be extinguished. And this I know you're going to probably argue with me on. Must be extinguished unless the way provides access to public land or water, in which case the municipality must define the extent and purpose of the public use of the road and must be a paying member of any road association formed and contribute its fair share to the cost of maintenance. Then I took out the whole thing about waiting for 1 year because I don't think it should necessarily have to be in that 1 year when they're discontinuing the road. And sometimes that delays the process of discontinuance. What I'm saying is go ahead, let them discontinue the road, but keep a public easement. But at any time, if the landowners can agree to grant each other private easements, then you can get rid of the public easement.
I'm gonna just point out that that's a takings in reverse. That means that they have to pay that community if you give up that easement.
But the town could just up and discontinue it and not keep the public
You can
easement.
extinguish the easement, and therefore there is a value of that goes back to the landowners.
So if you extinguish an easement, you have to pay damages? Is that what you're saying?
It's a takings. If you extinguish a public easement, it's a takings. In the same way that if you buy something that belongs to the public, you owe some sort of money to them.
So if I'm hearing you right, if the town discontinues the public easement, the town has to pay the landowners for loss of access. If the property owners discontinue the public easement, they have to compensate the town for loss of access? But it's the same.
It's a publicly owned easement. So the only way that you can have it extinguished is to go through that public process that has a takings component that's built into it and also has an assessment trigger that's different than if it were a private road, because the 2 are assessed completely different in Maine statute.
So you're saying the town has to discontinue it without a public easement at the time it does discontinuance, like it couldn't hold it for a year as a public easement, see if people agree, and then release it into a private easement.
Yeah, my understanding is that there's a constitutionality piece associated with that. They can do it at the time of the process.
Okay.
And that's why there is that time limit that's in there.
Okay,
So what towns are often doing is they discontinue the road but keep a public easement and say that therefore they don't have to compensate the landowners for loss of access because they've still got access. And they don't compensate them at all, or they maybe give them $1 just to make it official. But the truth is that because the public still uses the easement, they wear it out, and then that destroys the access.
And they can also appropriate money for the maintenance of that, which they can't do if the easement's not there. They can
But
also
they
help
won't.
out.
They can, but they won't. I don't know.
But we can go around about this like forever, like as every example that you have of someone that doesn't do it right, I have an example of someone that does do it right. So what matters is that the process is there and that we have agency on all of that. And that, I mean, like our charge is literally to find some solutions about things that we know. We know that people need agency and access to justice around this, to the courts or an alternative dispute resolution process with someone that is knowledgeable and is someone that's going to weigh all of the facts in balance. And we need to have that. We need to have public education. We need to have clearer pointing to the roads and the information that we have. And we need to try to limit the liability for the folks that are on there for doing the good work that they want to do, and try to limit and make it more possible for folks to have that agency on the roads that the town can't deal with.
Okay, where the town does keep a public easement for, say, access to a public boat launch or something to that effect, or to public parkland, is there any way that you can see of saying that the town needs to provide some maintenance if there's a road association and everybody else is paying for maintenance of the road, but the public isn't, and maybe there are 10 public cars going in and out of that road every day, but the landowners are ending up paying the whole bill? Is there some way to fix that problem?
Is there a road associations that is so, I mean, is the road a private road? Because a road association is associated with that. The ability to extinguish the public easement, which gives them the ability to bar it off.
Wait a minute, say that again?
You're talking about, you said two things. You said a road association and that they would have to pay into a road association, which then assumes that there is no public easement.
No, because there are road associations on public easements, which I also see as a problem, because then you're forcing private individuals to maintain a public road. But this is what's being done in the town of Wyndham, for example, where they're trying to get all their private roads to be public easements.
Well, that's because those people have benefited from that, and they have to currently go through every single year and ask for that easement from those folks. They have to have legal documents showing that the town has an easement for that purpose.
Now, what I'm saying is take an example of a discontinued road that has a public easement on it. The town has the right to use their town equipment on it. They have the ability to do that. But if those people on that road get together and form a road association for maintaining the road, and as I said, if there's a public boat launch or something that's using that public easement for access, shouldn't the public be a contributing member of that road association?
They can go in and provide, as they do and have before, maintenance material for it. But if that road, they're not going to pay a public, a homeowners association for that purpose. They can use their equipment if the town votes to appropriate for that. They can provide that limited maintenance.
But what if the town votes not to? Is that right?
You tell me. Do you want to pay for you constantly say, oh, I don't want to pay for schools because I don't have kids in schools, but you have to, because that's what the Constitution says. That is a fact. That's a member of being a citizen of a society. We have a duty and obligation to educate our citizens. We all pay for things that we don't necessarily use or want in a community, and we have a very finite ability to determine what that is.
Now, you're misquoting me. I didn't say I didn't want to pay for public schools. What I said was that if you're paying and getting nothing in return, then there's something wrong. Making an analogy between paying for schools and paying for public easement isn't right, because the situation on a public easement is like saying, okay, you can build your own school, but then you have to let the public attend your school for free. That's what you have when you have a public easement, because you're both paying for the public roads and you're paying for your privately maintained road, and the public gets to use your privately maintained road.
In reality, your road is not a highway. There's not a massive amount of people that are going down a dead end road. The state has determined that the waters of the state of Maine belong to the state of Maine. So access to water is something that Maine has prioritized as a state. And there are many reasons why that public easement is protective of the access to those water bodies, because otherwise a whole bunch of people with a lot of capital can buy an entire lake and cut all of the residents who live in those communities away from it. That's the purpose of a public easement.
And they have.
Mhm. But I still think if there's going to be a public easement, that there needs to be some public responsibility for maintaining it. Anyway, the last one that I had is abandonment. And this one has a lot of little changes to it. First of all, when it was revised from 3028 to 3028A, a lot of things got kind of lost in translation. One was that it says that a town or a county can abandon a town way. It doesn't say that a county can abandon a county way. So everywhere that it says town way, I put in town way or county way. Jim pointed out that it keeps talking about discontinuance by abandonment, and he said that's confusing. You should use one term for one thing and one term for the other thing. So he said, take out discontinued by abandonment and just call it abandoned. So I did that throughout. Then there are a few bigger changes. One thing that it's the 3028A says is that the municipality or county gets to decide whether or not a public easement will be retained. And it doesn't say anything about on what basis they should decide that. So what I said is that a public easement must be retained if failure to do so would leave any property legally landlocked. Because I think that's a piece that's missing in there. And then, as I did with the discontinuance, I said at any time the abutting property owners may use the discontinuance process as detailed in 23 MRS 3026A to extinguish the public easement by establishing a shared private easement. And I know you're going to argue me the same thing on that one, so I'm just going to say, you know, that's already been stated. The time limits, I think, are unreasonable. It takes a person a while to kind of get their head around what's happening when a road is being abandoned. And I don't think that 10 days is sufficient notice. Let's see, there's a few places where time limits come in here. Down in paragraph B. Let's see, if the only means of access to property in an adjacent municipality or county, let's see, they should give the adjacent municipality or county at least 60 days prior to the meeting. And down in public hearing, the written request for a public hearing must be received by the municipal clerk or county clerk no more than 30 days, not 10 days after the notification issued pursuant to subsection 3. The public hearing shall be scheduled no sooner than 60 days after receipt of the request for hearing. And the reason I want that extended is because, as I said, it takes people a while to, first of all, to figure out what's happening. And then in order to file a petition, that's another change in that paragraph 4. As it is now, it says the written request has to be signed by at least 25% of affected property owners. Lots of times, many of the property owners live out of state. It takes a while for the person to figure out how to get in touch with them, and then they have to explain to them what's happening and why it's important and why they need to be involved. And that can be difficult, if not impossible. On our road, for example, when we first went through the problems with it, we were the only resident on the road and all the others were woodlots, and the owners of the woodlots didn't care. There was no way we were going to get 25% of them to sign a petition to go with us. There were other people in town who would sign with us, but it has to be the affected property owners. So we couldn't have gotten up a petition, certainly not within 10 days. So I said, if any affected property owner asks for a hearing, there should be one. And then give them time to get together the information. They need to be able to find evidence of whether that road is actually abandoned or not. Has it been maintained within the last 30 years? More than just isolated acts of maintenance. Has the town considered and used the way as if it were a public way? Is this really a road that should be abandoned or not? So they need to have some time to pull that information together. And then down on the bottom of the next page, this is something that I've actually seen happen, that somebody filed a request for a hearing with the town. They asked the town, who does this petition have to be filed with? And they said, file it with the municipal clerk. And after the 10 days were up, the town said, oh, we checked with our attorney and with our Board of Appeals and found out that our Board of Appeals is not authorized to hear this kind of a complaint. Therefore, you'll have to appeal to the county. And by then the 10 days were up, they immediately appealed to the county, explained to them what the situation was, that they had been told by the town that they should file with the town, and now the town's saying they can't hear it. And the county said, sorry, your 10 days are up. So they got no appeal. So I put in here that filing of an appeal with the municipal clerk within 10 days shall preserve an affected person's right of appeal in cases where it is determined that the municipality's Board of Appeals is not authorized to hear the appeal. The appellant shall have 10 days from their receipt of notice of such determination in which to file their appeal with the county. And I realized that I put 10 days there and I had put 30 days elsewhere. So that should be corrected.
So both of the 10 days, you should have 30.
Yeah, I think 30 was what I said on the previous page.
Did you mean,
Yeah, 30 days.
So
did you mean to change that in number 7 as well, where it talks about filing the appeal request within 10 days?
Yep, you're right. And then on the last page, the revised 3028A also says that a town or a county can decide that a way is abandoned by common law. And it says it does not alter the ability of a town way to be abandoned under the common law presumption of abandonment. The problem with common law is that you have to prove that nobody has used it, which is a harder thing to prove than proving that the town hasn't maintained it at public expense. So there are cases where somebody who lives on the road will say, oh, it's abandoned by common law, and they put up a gate. And there hasn't been any court determination on it or any examination of the facts. They just claim that it's common law abandonment. And if the town or county is going to have some right to say, oh, well, it was already abandoned by common law, I think there need to be some guidelines on that. So I said, a way must not be declared abandoned by common law, except when there's that either A, no property will be legally landlocked thereby, or B, the road has been entirely unused, even by owners of abutting property for a period of 20 or more consecutive years, as shown by evidence of physical obstruction of the road for that period, or by evidence of the age of tree growth within the traveled surface of the road. If you have a road that has 20-year-old trees growing in it, close enough together that you cannot drive through between them with a vehicle, then chances are that road has not been used by anyone for 20 years. And the reason I say that even used by abutters counts, there's another law that gets confused with this one. If somebody petitions to have a road established by prescription, then they cannot establish a public road by prescription if it's only the landowners using the road. But that will establish a private right by prescription. And a lot of people have kind of mishmashed these two together and said, well, if you have to have somebody other than the landowners using the road to prove that it's a public road by prescription, then if only the landowners are using the road, that doesn't count towards preventing abandonment. Well, the problem with that is that common law abandonment extinguishes even the private easement. And there should still be a private easement there if the landowners have been using it. There is in fact one case where there's trying to think, Doobie, who's one of the parties, where the court said that use by the abutters was the purpose for which the road was established in the first place, and therefore their use was public use. And as my husband points out, we have no deeded access over the road. The only access we have is because it was a public road. So therefore our use of the road is as members of the public. So you can't just say that use by abutters is private use and therefore it doesn't count. Any comments? Either everybody understands me perfectly, or I've got you totally confused.
We don't advise municipalities to use this statute. Common law abandonment is still available to them. The statutory process for abandonment, I mean, roads are not abandoned, they are discontinued. And I think some of the things that you're thinking about as you're writing this are historic things that can't be changed. But there isn't this massive swath of abandoned roads or a process. The positive process is discontinuance. That's what municipalities are doing.
So why is this section even in the law if it's not something that?
Because it actually established, because common law can't be extinguished, it established a process for abandonment that was greater than common law. If you want to, it wasn't necessary, it wasn't just the way in which the common law abandonment had been established. You also had all of these other pieces that you had to, the time frame was longer. Common law abandonment is much lower in its threshold. And there wasn't all of these other pieces there. It was a higher hurdle than common law abandonment, but it's still a finding of fact. This is just discontinuance by another measure. So discontinuance is what we would always advise municipalities to pursue.
So are you saying you don't advise municipalities to use the abandonment statute at all?
They have the capacity when there are certain conditions that are present to declare it abandoned. But again, it's a finding of fact. It's not a positive process. And the finding of fact that was in the statute before was a higher threshold than the common law finding of fact. And that is the reason why there was that section in law to begin with. The process of saying we no longer want to maintain this road is the recommendation that we've always made, is to go through the discontinuance process, which has a public notice, which has a public hearing, which has notifications, and a declaration of whether or not there's going to be a public easement that's retained.
So why not just go with discontinuance and get rid of the abandonment statute?
Because the abandonment statute was in statute specifically to be a stronger process and a longer process than what common law abandonment is. Common law abandonment is still available, but when it was in statute, it had a longer period of time in which and it had a public maintenance piece of it, not just a public use piece of it. So it almost was better the way it was before, because it's still a finding of fact. This is just discontinuance by another process. I mean, that we could rehash that hearing all over again, but we kind of outlaid that during that time. It's there. Since this law has changed, there hasn't been a community that has declared it abandoned through this process. They've gone through discontinuance if they've gone through anything, but even that happens on a very limited level.
You know, what I see happening sometimes though is that because the process has gotten more complicated for either abandonment or discontinuance, that roads are refusing to do either. They just stop maintaining the road and leave the road in
We
limbo.
can't do that.
They can't, but they do.
Then there's recourse for people that are not having that maintained.
Yeah, that's another thing that needs to happen is that people need to be made more aware of what their recourse is. I know of cases where people have complained to the town repeatedly that the road needs to be repaired, and the town just ignores them until they reach the 30-year mark. And most people don't know about Title 23, Section 3651, which says that the towns are responsible for keeping their roads safe and convenient, or about 3652, which says they can appeal to the county. You know, we're one of the lucky ones. We heard about that, but somebody can complain to the town until their face turns blue, and the town can just ignore them.
The town can't ignore them. The town has
They
responsibilities.
do, but they do.
I would argue that people are very aware of what their rights are. And the one thing that you will hear uniformly in any town office are complaints about the roads. The roads and road maintenance are a constant issue, and there is agency, and all of the things that you just talked about get right back to that. We need an alternative dispute resolution process.
Okay, well, let's work on that. How do we get an alternative resolution process?
I think that that's something that the committee can make a recommendation for, that we need to have an alternative dispute resolution process that also doesn't burden the courts. You know, so you're not waiting the same time limits in order to have access.
And I know that mediation can happen a whole lot faster than getting a case to court, especially since COVID. The courts are backlogged and it can take a couple of years before they even start addressing a case. And mediation can often happen within a matter of weeks.
Absolutely. And I think that process could actually, you know, have that built into it as a first parameter to try to get to that. But then at least all of there'll be a heavy lift that if we go through an alternative dispute resolution process that happens so that you're not cutting that person off from appealing. They can still continue to appeal, but then you have like a whole bunch of factual information before it gets to that space. And some people at the end will be okay with that, but.
And hopefully that will preserve access while they try to sort it out. But also keep somebody from coming in and making major changes before they sorted that out. Because I've seen it go both ways. You know, there are people who live in a house on a road and somebody else buys land on both sides and shuts them off, and all of a sudden they have no access. And they have to wait 2 years before it makes it to court. On the other hand, you have the person who's got a road that has 20-year-old trees growing in it, and somebody who actually has other access from the other side doesn't want to cross their own land to put in a road to the subdivision they're planning to build. So they come in and they bulldoze down the 20-year-old trees. And that shouldn't happen either. There needs to be some way to put things on hold until it gets sorted out.
Roberta, you,
It's a neighborhood divorce court.
go ahead.
Neighborhood divorce court. So
Family and community mediation.
You've mentioned a couple of existing ADR programs that we might look at. Do you know how those currently work or how they're structured?
Okay, I know a bit about them. Family and community mediation I have put them in contact with Jim to see if they can discuss what might be available. Most of what they do is family stuff, divorces, custody, things like that. But they will also do community mediations, which could involve something like this. The agricultural mediation program is already doing things like this occasionally. Mostly what they deal with is they exclusively do stuff that's related to either a farm or forest land that is in production. They cannot address a case where it's just a hobby farm, somebody with a garden or somebody who cuts wood off their own lot for their own firewood. It has to be actually in production. So that kind of limits the cases they can address. But where there is forest land or farmland involved, they can address these issues. And I know of one case that they helped with recently. It looked promising. They had a tentative agreement that went out of the mediation. And it's a matter of whether the parties can now agree on finalizing that agreement. This one apparently they've been working on for some time, and they've been back and forth with the mediators a few times. But I think they're getting closer to resolution, but it involved a discontinued road.
And are the mediators in that case, or cases where they help out like that, are they going back and doing the research to find the status of the road? Or are they just working at the higher level of trying to resolve the dispute without?
They haven't done
Getting
enough
that
of it
far.
yet to really be into that. And that's one of the things we have to look at is how do we equip them to do this other category of cases. They do regular trainings, where they'll have one of the mediators who specialize in his particular area, usually on Zoom, they'll do a training where, other mediators can come in and find out what the technicalities are, how do you figure out who owes what in a custody case, whether it's shared custody. If there's a divorce, how do you split it up? If there's a succession, somebody has an orchard and they want to retire and they want to grant the orchard to their children or grandchildren, how do they divide it up? They have trainings on those kinds of things. So it'd be a matter of doing trainings on how to sort out a road.
Well, I think that Jim wrote this book for the Bar Association about these problems.
Can be a whole new line of business for him.
Yep. Sounds like a soft retirement job.
Okay, well, that's what I had done so far. Like I said, it's a work in progress, and I'm sure there's still things we're gonna have to hash out on them, but you can take these home, look them over, see what other ideas you have.
And I did find, so, when I got back, I went to a concert and I did get COVID, so.
Sorry.
Yeah.
You've had a rough couple of months.
So, but I would do it again because the concert was that good. But that being said, I did find it in my phone and I was just down and out. So I apologize for that. I was just 2 floors up. That's not a biggie. I knew if it wasn't, no, I was 2 floors down. So I came up.
It's
so.
okay. It's, I'm a new clerk too for this position. So trying to figure out like what
Oh my
works for
gosh,
everybody
yeah.
too. Do you know what I mean? Like sometimes it's just easier for me to maybe send out an email to people ahead of time being like, just a reminder, we're
Yeah.
in room on this date.
No,
So,
you know what you usually did was you usually sent the agenda again and you rectified that. This time you just sent an email.
I did. I'm
Yeah.
sorry. I
Or
apologize.
if you put in the subject line Zoom meeting.
I'm trying to figure out like
It's
what.
never gonna work.
works
I'm gonna
better.
I've
I've got you now situated, like when I set up the Zoom meetings, that you get the email now, right, with the information in it, because you couldn't see it before, so I figured that out. I'm a work in progress.
Yeah, no, but it's, yeah, that was my bad. But I mean, I'm in the building, so it doesn't matter. I can go every floor and just look in a room.
I
and see
should
if
probably
we
just
get-
give everybody my phone number so that you guys can just call
Yeah, I
me.
thought of
So
that,
I'll
yeah.
send that out.
No, don't do that. You'll never hear the end of it. We'll be calling you all the time.
That's okay. I'm
gonna
on
roll
duty
it
at
out.
4. I just turned the phone off, but.
I'm
you
only
know.
gonna call you if I'm on the wrong floor, I promise that.
Or if I'm gonna be 20 minutes late because there's an accident on the road in front of me.
Yeah.
Something like that.
Yeah, and I was also thinking I
And
should
you've been
probably
there
have
before. Yeah.
everybody's phone number and contact information too for the commissioners, so that like when Jim's running late or something, we haven't heard from him, I can text him and be like, just checking in, you know? So I was thinking
Yeah,
that
'cause
too.
I think at one point you sent me an email saying, are you on the way? And because I was on the way, I didn't get the email.
I know,
don't
and that's
have
the
a cell phone. I
downside
have
to
a
just,
dumb phone.
yeah, I just have everybody's email. I don't have contact information really. I don't have addresses and I don't have cell phones. So I know this commission was thrown together pretty quick and you guys have really got up and moving quite quickly. So that might be something
So
to
the
talk about.
commission itself wasn't set up quick. It's the subcommittee
Yeah.
that was a tough one.
Yeah,
That that one is, you're getting emails from the commission, you're getting emails from the subcommittee priority group, it's like, I sorted it out, but.
I
it's-
try to
forgot the
put them in
word.
the letters, but yeah, I know, I'm sorry.
Yeah,
keep-
I'm not surprised I missed something, I'm really not surprised,
When you
so,
get 40 emails a day.
Yeah.
You lose stuff.
yeah.
But
Yeah,
we're so much better with you, Heather, because otherwise, you know, Vivian couldn't have done all this split out, and you've already brought us into the 21st century. So.
Yeah.
Well, thank you. I'm still waiting for them to send me my password for the webmaster stuff so I can go in and change things. So I gotta bother them too. So I was giving them a few days because there's a bunch of things they still needed to fix, but you know, eventually we'll get there. So
I can't wait until we get the website up and running.
it is up. You can see it. It is up. It's live. So I'm just waiting now because they made me the webmaster, but they haven't sent me my password and stuff so I can add new meetings. But they were saying they were having some issues with like the mobile phone devices and how it was appearing. So they were tinkering with the page. They didn't want to give it to me till such time. And I said, fine. Like, I don't want to mess with it either, really, but
Did I miss it or did you send out? a
I
link
sent
to
it
the-
out with the email for the meeting for October,
Ah,
along with my warning that I'll be gone the week before.
okay.
So if everybody can get me, if there's a lot of stuff, get me the week before I leave, like this coming week, which I know is coming right up, just so I can have everything printed and ready to go. Otherwise, I'll be back and hopefully I don't get COVID from traveling, you know.
Oh, it's
so
really a lot of fun.
I'm
We
not
have-
training.
We have our annual convention this week, and I want to be able to, you know, go back into that language piece. But so I don't know that I'll have it before you take off, but I will
That's
definitely.
okay. I think I'll be okay. It was more just kind of giving everybody a heads up so that everybody kind of knows. You know, that I'll be indisposed that week. I won't be probably checking email because I'll be out on the West Coast.
You definitely
training.
should not check email.
So-
There's a firm need to disconnect, period.
But I'm supposed to be back that Friday, so I would think by that Monday, Tuesday, I should be in, and I think the meeting then is what, Thursday? So I just wanted to give everybody a heads up, make sure everybody had time, and
So we don't have an agenda for October's yet meeting.
I think I sent a basic agenda for the
Oh.
October.
And I
So,
think I
right?
may
It was a
not,
basic.
I think I may not even have opened that on the theory that if I open it, I won't be able to find it. If it's still in black, I'll know where it is.
Yeah, I sent out like quite a few. You're on 3 commissions, so 3 committees, so you get everything, so. But if not, I can resend it out to you, Kathy. Just let me know.
Okay, so this is the meeting that will be on October 19th.
Yes.
This will be exactly a year that we've been doing this.
Wow.
Wow,
That's crazy.
I need a bigger book.
And I still have to go through my file box and sort things because I've got things just sort of thrown in there.
So, yeah, okay, so I'll look and see, but I might have to have you resend.
Yeah, absolutely.
I don't believe, I thought I had done a whole bunch of stuff.
You know what I could do, come to think of it? I could open that email and then forward it to myself with the heading on it that I want so I can find it, and then it'll be higher up on the list.
It will be. I mean, I also think it will be, there's a couple of things too I want to talk to the commission about now that we've transitioned over to the YouTube page and we'll have the meeting notices up on the website to be able to click on. And I'm hoping I'm gonna try to see if I can't get people to redirect just to YouTube unless somebody's testifying or they want to make public comments. Because so many of our commissioners are remote, what's happening is I've kind of locked down the comments, which is what has been recommended by our IT department and what my Zoom license allows. Because there's been a lot of public stuff going on where people log in and they're just like razzing people. So I have stuff kind of locked down, so it makes it harder for the commissioners. So I'm trying to figure out if we can just do a YouTube and then those people who want to testify can be on Zoom. Because we know who those
Similar to the
people
way they
are.
do it for the last, like,
Exactly, and then
years.
those people who just want to watch or whatever can be, but then I don't have to log down the commissioners because I feel like they should be able to just speak when they want to, or be able to send a group text, because that happened the other day to, I think, Ryan. He wasn't able to send it to the group because of the way the settings are on Zoom, which I talked to IT and they're like, well, that's kind of our settings because of the recent stuff. So it's all just stuff to kind of figure out technology wise.
So I have that on October 19th at 1:30, we're meeting on the 3rd floor in room 300.
Yes,
Okay, so I do have.
I am not able to attend that meeting.
that's fine.
Do you need me to send you an email? or
Yeah,
anything?
just so I have it.
Okay.
Yeah.
Oh, yeah, there was something I need to ask you about that came up at the other subcommittee hearing.
1 second. So are we all done with the committee stuff? So I can let Rebecca go because she might have more things to do.
Can I just
Yes,
bring up a,
sure.
I may or may not have an answer.
okay, well, it was in the statute that went through a couple of years ago about, where there's a resident on a private road, it's assumed that all the property owners share the maintenance. And they originally proposed it to be that all the residential property owners share in the maintenance. And I fought hard against that because I said, what if you have, a rock quarry or a gravel pit or a lumber yard or a logger that has property on the road and they're making heavy use of it, they tear up the road and only the residents have to pay for maintenance. So I fought to get it that all the owners share. And Jim pointed out that, Maine Woodlands are not gonna like you for that, because if somebody is only using their road once in 20 years when they harvest their property, why should they have to pay for the rest of the time? And I thought, yeah, he's got a good point there. So it isn't in this stuff because it's for the other committee.
Yeah.
But I put in some language that says that the owner of a woodlot doesn't have to contribute except when they're doing a harvest. And then they have to leave the road in no worse condition than they found it.
I mean, a reputable logger would do that anyway.
Right, yeah.
But
But we've seen some that aren't, unfortunately.
Yeah.
Most of them way back. And I think they've gotten more responsible over the years.
well, I'd have to see it, I'd have to take a look at it before I could comment on
Okay,
it. but-
is it okay if I send that to her directly or does it have to come through you?
I think it's okay if you, why don't you CC me on it?
Okay,
Just put me on CC. So that way, or you can send it to me and CC Carla.
okay.
And then that way it's coming to me, but Carla can see it. Otherwise, I don't mind forwarding it because I have the stuff that you sent to Jim with those changes on that one,
Mhm.
where it says, only if they're using the road at that time do they have to pay to maintain it,
Right,
which I thought was a good, maybe loophole for the loggers, because they don't use it for 20 years.
Right.
So you just let me know. I can either send it to her directly, or you can CC me, or I can CC both of you. Doesn't matter to me.
okay,
I'll take a look at it.
Yeah.
It'd be great, thank you for the heads up.
next, this is one of the things that I've fought for is we need to get everybody together, because if we solve it for one group, somebody else is gonna have a problem with it. So if we get everybody together. And hopefully we can find solutions that work for everybody.
All right, so is there anything else anyone wants to discuss?
If we
I'm
actually, if we have comments about what Roberta has proposed with any of these proposals, I obviously haven't had a chance to really spend a lot of time with them.
And I apologize for not getting it out
No,
sooner.
that's okay.
This has been just a crazy week.
I know you're overloaded with committee work.
I
What-
was also away at Common Ground Fair for 4 days.
Oh, right.
And I've been asked by a local farm to pack onions for them.
Oh,
So
wow.
I've been-
Going in a bunch of different
Yeah,
directions.
and what was it, yesterday and the day before, I got 4 people emailing me about their roads all in one day.
I'm busy.
Yeah.
Should I just put them in writing somehow, since I can't come to the next meeting, or what?
Yeah, I think so. If you write up and email me, I can share it with the rest of the commission, which is, I'm assuming,
Okay,
what you want, right? And then how Jim has it broken down on the agenda is that the terms group, I think, goes first and like their breakout and their solutions, and then it'll be the priority group again. And I don't know who wants to present again, if you guys volunteer Roberta again, or who wants to be, but she could then present your stuff too, or I can just hand it out and be like, these are Carla's concerns, or.
I don't know that I will have comments, but I just wanted to flesh out the process in case I do.
Yeah.
Since I can't be there, I'm sad to miss it. It sounds like it's gonna be a really important meeting.
I'm sure we will have one in November too. I have a feeling. I think it's gonna be a lot of work to put together
Yeah.
the report to the legislature, I think. So
And that report will be when?
just, it's due January 5th.
Okay, because that's when they're coming back in session.
So I think Jim wants to have it done by December 5th. And then have a month to be able to play with it and edit it. So I would say the next meeting is when he really wants to see the changes and recommendations that everybody wants, and the committee can start, and commission can start voting on it and figuring out what they want. And then between October and November, start putting together the report and everything else and have a little leeway. And then by December, actually start writing the report and have it done. He wants it done, I think, by Christmas, because he doesn't, I don't think anyone wants to do that over the holidays.
Yeah,
So
I didn't realize it was due that early. I was thinking it was like last year, February 1st.
no, January 5th. I mean, I don't know if we can ask for extension of time or whatever. I don't know. Jim seems like he had it pretty well in hand because he was like already starting to write the memo for stuff. So I don't know. We'll see. But I think sooner is better. Sooner is always better. The sooner pull it together, even if it's just a list of recommendations. But I think he really wants to do the legislative law, so they can't say no or give it back to us. I think he just wants it to go.
Basically, so the concept of what we hope has achievable language at the other end. I think that's why he wants to do that, because this past session was the session of ideas and really bad language.
Exactly.
Achievable.
Yeah, and I'm a stickler for language. There are things that I'm always catching where, like there's an ad on TV for, do not use this medication should not be given to adults with diabetes or children. No, this medication should not be given to children or to adults with diabetes. Just, why can't you just make that simple switch and make
Easy
it clear?
fix. All right, so is there a motion to end the meeting?
So moved. Second.
All right, meeting is adjourned. Thank you, ladies.
Thank you, Rebecca.